said yes? Okay. All right, we're starting. Welcome, everybody, to the October 10th, 2024 copy of Town of Monroe Planning Board Workshop Meeting. Noreen, roll call, please. You know what, you're sick. We'll just go down the line. If you start, just say your name and present.
Bob Garstack, present.
Jeff Manson, present.
Bonnie Franson here.
Matt Shea here.
All right, we have a quorum so we can conduct business. I'll point out the fire exits. There are two in front of me, one to my left, the main access point, and then another out this way that leads to a patio. So with that, could we all please stand for the Pledge of Allegiance? I pledge allegiance to the All right, we're going to switch things up a little bit because our engineer is not present, running a little bit late. So we will take up Target. Good evening. And if you could state your name for the record.
Button on the top. Okay, we're good. My name's Casey Lieberman. I'm a civil engineer with Kimley Horn, and I'm here on behalf of Target Corporation.
Right, so I believe I wasn't here when this started. Jeff, you may have run that meeting, so if you want to give us an overview of where we are in the process.
Yes, at our last meeting, we've been presented with some architectural updates that were for us to review for Target in Monroe and for our approval. Effectively, nothing is changing with the footprint of the building. It's really all cosmetic items. And this is being all the Target stores over time.
So were there any changes that were made between or same, there's no changes?
So it's really just improvements to the facade. So upgrading the paint, changing the colors a little bit for a better aesthetic, I believe.
No revisions to the,
No. Oh,
Okay.
since the last time, no revisions. We just had to be, sent to the
We're
county
waiting
for
for
approval.
GMO review,
all right,
and
which I do believe we received,
we did.
and it was local determination.
The only comment that they had was in relation to the size of the signage and just ensuring that that met our code. I believe Sean addressed that in our last meeting.
Yep.
And we talked about that just to make sure.
It's all code compliant.
This was the GML review that we received, and so board members, do you have any comments, anything to raise or address regarding this application?
Nothing for me.
Nothing for me.
All right. So with that, I believe our attorney has drafted up a resolution for us. I'll bring that up. So, and the reason it is before us is it's subject to architectural review. Everybody receive?
Yes.
I'll just scroll through it and paraphrase. Target is seeking architectural review, approval for exterior modifications. As just brought up on screen, the Target is on Farm Road. Project within the LI Industry Zoning District and the Business Park Overlay District. And then there's a recitation of various submissions that were made. Application was filed on August 8th, 2024. Public hearing is not required, and in terms of seeker, this is a type 2, not subject to seeker application. We have to fill in, I guess, the date.
Yes, so I did modify that. It's dated September 27th, 2024, and I did just modify to track the language that they used specifically, was that it's a matter for local determination, there being no evidence that significant intermunicipal or countywide impacts would result from its approval.
That's been adjusted. Findings, planning board has determined in exercising its power of architectural review that the exterior design, arrangement, texture, materials proposed to be used are architecturally appropriate and visually compatible with the existing buildings and environment, and that the alterations are consistent with the architectural style of the existing building and surrounding area, and otherwise in compliance with the standards of Section 5731. So there are a couple of specific conditions. Final engineering review of the materials. Resolution won't be signed until receipt of a letter from the planning board engineer certifying that all deficiencies in memo addressed. We'll submit an owner's endorsement by target. Design of the building colors materials shall be as specified. And then no building permit will be issued.
I need a change on that.
Okay.
In number 4, where it says architectural review board, I changed that to planning board because you're acting with your architectural review capacity, but that you're not actually considered an ARB.
And it discusses the interiorly illuminated sign shall utilize non-glaring lights. Approval only allows construction of what is shown on the plans. No other outdoor amenities or other fixtures are being alteration. Prior conditions and requirements of the original site plan approval apply. And then there's a whole set of general conditions which are standard for our typical approvals with regard to submission of approved plans, et cetera. So with that, would someone make a motion to adopt the resolution as amended?
So moved.
That's Pat. May I have a second?
Second.
Bob Gorstek,
Aye.
Jeff Manson,
Aye.
Bonnie Franson,
Aye.
Pat Shea.
Aye.
And with that, the motion carries and the target signage is approved.
Thank you. Have a good night.
If you have any questions, you can call Noreen in terms of submissions and how to move forward with the final.
Thank you.
All right, next on the agenda. Go back to Lands of Leva. Is it Leva or Leva? Leva, thank you.
Turn on that mic, pull it towards you.
Yeah.
Hello?
The other one was working.
Hello? There we go.
There you go.
All right. Vince Petersak for the Lands of Leva. This project was approved under the old zoning for 18 lots. We filed the first phase consisting of 10 lots, and then it got caught up in the zone change for the remainder of the property. So we took a look at the existing configuration of the road, and instead of extending the cul-de-sac back further, we just did 4 lots off of the end of the cul-de-sac with 1 lot off of Rye Hill Road. So there will be no infrastructure improvements, and we reduced the yield by 2 lots from the previous approved plan.
Right, so I will ask our engineer, if you just state your name for the record, you're not usually in front of us.
Sure. My name is Jamie Zajac. Apologies for being late.
No worries, we got the message, thank you. And there should be a review record, correct?
Yes. Comment letter.
Okay, so
Oh, he just typically goes through every line?
Yeah,
Sure.
highlighting especially or discussing the points that need a little bit more explanation.
So all the lots wholly or partially located within the town's Ridgeline Preservation Overlay District and the Watershed Protection Overlay District. So those are two comments that Sean had. One, being within the town's Ridgeline Protection Overlay District, the board can request submissions, including a visual assessment for the proposed improvements. So there's a whole section in the code that kind of describes what the board is allowed to request. Watershed protection overlay, the narrative, Sean suggested a narrative be provided on how the design standards are met for both of those areas. Both of them have sections in the code. The watershed protection overlay specifically has a number of design standards that should be met. So that's one recommendation, that the applicant provide some type of narrative that explains how they plan to address both of those sections in the code. 3, based on a review of the Orange County tax maps, the tax map identifies the Phase 1 roadway construction still in ownership of the parent parcel. The applicant should review this and identify if any dedication has been taken by the town for the existing roadway.
Vince, if you want to add anything as we go along, feel free.
Oh, okay, I'm sorry. I was
Sorry.
going to wait till he was
Or
completely
we
done.
can wait till then, whichever.
The
works for you.
attorneys are working on that road dedication with the town right
Okay.
now. Sorry about that.
That's okay.
Number 4, the applicant should clarify the extent of the proposed sanitary sewer. So, looking at the plans, the main that runs down Stevens Court here, some areas are shown grayed out. Some areas are shown darkened and black, so it's a little unclear of what's existing and what's proposed.
Behind or running through the existing lots 11 and 12 from the existing roadway is a sewer that dead ends into Phase 2.
Well, then, 10?
And then that sewer is proposed from that manhole through the site to collect.
What about at the bottom of Stevens Court?
I'm sorry,
The bottom of, so the end of the cul-de-sac there.
yeah, that sewer is all existing.
That's all existing, okay. So
Correct.
so that's what I'm saying, if you go up Stevens Court, at some point, the line is darkened. And then some parts are grayed, so it's just a little unclear of what is there and what wasn't there.
Yeah, it'll be more clear on the design drawings. All of Stevens Court is existing and is being dedicated to the town currently.
Number 6, the applicant should show all proposed grading on the site plan. Number 7, the applicant is amending an existing SWIP. Therefore, the applicant needs to submit an updated or amended SWIP.
Yep,
Sure that's
we'll
already
take
known.
care of that.
The applicant should identify who will own the existing 50-foot right-of-way adjacent to lots 21-4.52 and 21-4-4. So that's what it looks like what used to be proposed as the loop road back to Stevens Court, the start of it. So if you scroll up on the screen there, see at the top of the page there's what was an existing right-of-way. It's unclear who will own that.
Yeah, we'll verify that on the design plans.
Okay. So that there's no connecting roadway proposed.
Correct. There's
There now.
no further infrastructure improvements.
I appreciate, but I will, let me finish. So after we conduct our business, because you have, come to view this, you can ask some questions then. But let us get through our main business. Thank you.
Number 9 on the comment sheet, at a previous work session for the applicant, there is potential wetlands on site noted. A small wetland to the northwest of the property is noted on the plans. The applicant should note if any other wetlands are located on the site and further should delineate those on the plans.
There are no other wetlands that we're aware of, other than that one in the corner.
I think at some point we'll do a site visit to confirm and maybe have our MCC go out.
And the board should discuss with the board's attorney if the application will require a realty subdivision approval from Orange County DOH.
I believe it will, yes.
I believe involves the phase 1. I think that the overall, the lots, well, this is 5 lots, but one of them's improved already. But I think because
Yes.
you consider them collectively? if
Yeah,
I
but we
recall?
still need to get a reapproval.
Yeah, I think because it's a
Either
phase
way.
in a larger subdivision, probably
Right,
that
correct.
it's still triggered. Okay.
And it's still 4 lots under, more than 4
Under
lots under 5
5
acres. So
acres.
either way, it's going to have to go.
Okay.
11, pursuant to Town Code Section A65-8L2, the applicant will need to perform well testing on at least one well. Usually that's a new drilled test well, but it looks like there's an existing test well on the
Correct.
site. Would the plan to be
And that was
utilize that?
tested for the overall project, so we will utilize that for
Okay.
reapproval.
The proposed sewer improvements will require sewer extension approval by New York State DEC and Orange County Department of Public Works.
Understood.
Number 13, lot coverage calculations should be performed on each lot. That was one of Sean's comments, but I think bottom left of the plan sheet, it looks like that is included in the bulk requirements.
Sean's probably looking for the actual number. We're just showing that it complies. We'll take care of that during the design.
Number 14, the number of bedrooms for each existing and proposed dwelling should be noted on the plans.
Okay?
And number 15, the application should review the need for a roadway connection to Rye Hill Road based on the conditions of the Phase 1 subdivision approval and the maximum roadway length in Section A65-21E1 of the Town Code. So my understanding is that part of the approval of Phase 1 was that cul-de-sac at the end of Stevens was temporary, and that there was required to be that loop road around the back connecting it back to Stevens Court.
So it was actually proposed to either connect that, where that temporary cul-de-sac is, where you have these 3 driveways coming off, to either connect that to the Feeney subdivision down below, or have a road directly out to Rye Hill, kind of on the bottom where you see, I think it's the existing driveway for
Lot 5,
for lot,
where Lot 5 is shown.
What-
or somewhere
That-
along the bottom
right.
of somewhere along the bottom, I think, of the property.
Yeah, the driveway for what is Lot 5 is actually part of the driveway for the existing dwelling that's up on Lot 1.
What the previous plan did was it extended the cul-de-sac another almost 600 feet, and it provided an access down into the Feeney subdivision, which we had subdivided also.
This one here? That says
No,
that,
down below.
Another
Down
one?
below.
look down below. Oh, okay, got it.
And we had subdivided the Feeney property also under the old zoning, which got hung up with the zone changes also. That access that comes down to Rye Hill was an emergency access that was provided so that we didn't have to extend the cul-de-sac back out, and we didn't have to build into the Feeney project at the time.
The one that's there now, you're,
Correct.
that loop? How does the loop,
You really need to look at the Phase 1 drawing that was submitted. That would explain.
Bunny, I could send you, I downloaded the entire Phase 1 plans from the county website. Those have a sheet showing the alternatives for the access.
this here? This is the signed,
Yeah, if you
All
go to the
department
first
maps.
sheet, it shows the emergency access.
so it's kind of this stem right here.
And this would be the emergency access that came down.
Okay. But it looked like this was going to come around, but it wasn't going to come around, or
No, we were ending the cul-de-sac
trying to remember this?
and not going to connect it back to
Okay,
make a loop.
okay.
And we provided a 50-foot access to connect into Feeney's project that was under design and also.
Go to the last sheet, I think it's sheet 10. Two alternatives that, so this project was part of the GEIS that was done for the Rye Hill corridor with all of the various subdivisions. So one of the findings, and then also was incorporated into the Phase 1 resolution, was that as part of Phase 2, what's now listed as the temporary cul-de-sac that they're seeking to make a permanent cul-de-sac, that would be removed, and there would either be a connection to Feeney or there'd be a direct connection out to Rye Hill. These are the two alternatives
Does-
shown there.
I think subdivision regulations cul-de-sac is.
So I don't think they specifically spoke about that. I know Sean pointed that out as another issue, but the concern was that the Stevens Court cul-de-sac is a cul-de-sac off of a cul-de-sac, and adding more homes to that not having a direct outlet to the main road.
All right, so we've gotten through those. Ashley, do you have comments?
So on that issue, that's one item that we'll need to work through and have the applicant address those findings and conditions of the original approval. We'll need an EAF submitted. I don't believe there was one. I just noted too that the application, the first page had an incorrect SBL. I think that got copied onto the agenda. So just Sean's asked the building inspector to weigh in on whether the home on Lot 2 is a rear dwelling under the code, which is a dwelling situated behind another dwelling that fronts to the street. So it's a cul-de-sac, so it's a kind of unique situation, but Ben's been asked to weigh in on that because rear dwellings are prohibited under the code.
For some reason, rather than calling them flag lots, they refer to them as rear dwellings, which is consistent with another town I was just looking at. But
Not always a flag lot, it could be a rear dwelling without being necessarily a true
Right.
flag lot.
right,
And at the same time, you could have a flag lot that it's not technically a dwelling directly behind, so. Subdivision plat referred to, I think, the old parcel number at the top, which was a little confusing, so if you could make sure to have the current parcel number. It was probably from when you had the original phased planning going on, but now that there's been assigned new numbers to that, make sure you have the right parcel number up there. Add the square footage, number of bedrooms, and house relocation notes. So because this is a major subdivision, since it's 5-lot subdivision, a cluster plan is required under your code, section 5721.7. And that can't be waived, it can only be waived for subdivisions involving 5 acres or less. So the code does have the cluster plan submission requirements, and that's section 7-21.7. Amy touched on the ridgeline preservation overlay. So there are some submittals that are required under the code, and then also some discretionary, so make sure you address those. And you were showing that you were going to relocate the existing driveway easement to SBL 31-123.2. That's proposed to be relocated, I believe, so that'll just need to be accomplished before any final approval. As far as seeker goes, it would be an unlisted action, and I don't believe it's within 500 feet of a trigger for GML review. Since it's a subdivision, you will require public hearings.
Remind us, so this is phase one. Was this part of, I'm trying to remember, a larger subdivision?
Phase two.
So phase one.
Phase one was already filed, so it was approved as a phased project. Phase one was filed, and then you have a certain amount of time to file the phase two map, and that wasn't done, and in the meantime, the zoning had changed. So essentially, that part of the approvals expired, so it's, although phase two, it's really as if it's somewhat of a new subdivision before you.
In terms of the old versus the new, Vince, can you go over what were the lot sizes and what now are the lot sizes as a result of the new zoning?
Yeah, the old zoning, the minimum lot size was 25,000 square feet, and the minimum lot sizes that we had put on our subdivision was about between a half acre and 0.6 acres. The new lot areas that we're proposing are more than double that size, with the smallest one being 1.4 acres and the largest one being almost 2.3 acres in size.
What was the yield that had been approved? Proposed yield?
Previously, for phase two, we had 7 lots total, and now we're showing 5.
Trying to figure out where this was, but now I understand. You go up to the top of Rye Hill Road, you take a right, and you go down, Ludlam Road's on your left, and then you go over a little hill and take a right into there. I used to know some people that went to high school with that lived back
It's a nice
there.
little
Why that
area.
was never finished. Don't have any other.
Okay, so first I want to make sure that I understand correctly why, the reason for the reduction in the number of lots and the new layout and plan is because of the changes in the code back in 2017, because the phase two never got filed.
Correct.
At the time when it could have been that.
Yes.
So it's not that this is a preferable design for,
Absolutely not.
it's-
You have 3 years to file the next phase after the first phase is done, and they never filed it in time. And when that zone changed, it just wiped out that last.
basically it was a whole new. As a comment, I just don't love the layout. I feel like these long extended driveways that run parallel to each other down to the cul-de-sac, it seems to make sense to me more that the cul-de-sac be extended somewhere into the area of where the loop at the top of the driveway for the existing dwelling be, and that there's shorter driveways and more regular lots coming off of that. Now, that might be a concern when it comes to the 1.36 acre lot. I know you have to get in at least an acre, and I don't know how much acreage is covered in what I'm going to describe as the driveway pipe that runs down to the cul-de-sac, but that design just doesn't seem all that sensible to me for a variety of reasons. So I have that concern. Do we know why, again, it was a different layout originally. Why does it make more sense to run the sewer off the stem that comes out of the middle of Stevens rather than from the cul-de-sac where it ends out there?
Simply because we're trying not to disrupt the existing road that's in place, where we had that cul-de-sac. We originally were going to eliminate it and extend that road up to a new cul-de-sac. We still had that existing sewer manhole placed back in Phase 2 for future tie-in on
Right.
the previous job. So it just made more sense not to disrupt the existing road, which is being dedicated to the town, and come in with the sewer that works for all the lots up top.
Is the sewer there already, though?
The existing sewer manhole is on the lot at the end of
Right,
Phase 1.
right here.
Right. No,
No, in the back,
In the
kind of in the
back?
back of Lot 1. You're talking about that sewer man. That exists.
yes.
It was basically done to extend out into Phase 1 based on the original plans.
Correct. Yeah, it was already there, so it just made more sense just to bring it up and tie everything into it.
Right, so these houses are here.
Yes,
How are they
Or most
served
of
by
them.
sewer?
they're served by the sewer in the road.
Okay. And so that goes up to a certain point,
And
right?
stops right there, correct.
Okay. But again, you're saying it wouldn't make sense to extend this and attach a wall to this?
No, because we're dedicating that road to the town, and we don't want to rip it up and have to repair it when we have a sewer manhole right on site that we could tap into.
I guess the reason I ask is because this says it's a temporary turnaround to be converted into a permanent cul-de-sac, so,
That's when
There-
Phase 2 was going to get extended to the next cul-de-sac.
right, but I mean, this has to be finished up anyway, so you're extending it from a manhole here, aren't you?
No, it's finished. The road's done. It's being dedicated to the town.
And including the cul-de-sac?
Yes.
Because that part of it's on this phase. I mean, it may be, I'm just, I'm
Correct.
I'm
So I think the
asking.
cul-de-sac, it exists, it's being considered, it was considered temporary at the time of Phase 1 because it was not going to remain a cul-de-sac, but now they're seeking to make that permanent as part of this. So as
Right,
far
but
as,
it's not permanent and probably isn't dedicated at this point because it's on this lot.
It's being dedicated now, though.
Yes, but my whole point is that we're saying we don't want to disrupt the road, but it seems like we're only disrupting the cul-de-sac, which will become permanent. And I don't know, it's just, in the end, I think it's an engineering question
so I think
because-
there's also that question of whether it could become a permanent cul-de-sac with your length of cul-de-sacs and the issues we discussed with the connection to Rye Hill or the Feeney, so.
But I'm even also talking from the option to use which sanitary sewer probably depends on gravity flow versus pumps, and I don't know, that's an engineering thing.
I think what Bonnie's saying is it seems like it'd actually be less of a hassle to run it from that existing sewer manhole, at the end of that cul-de-sac.
If it makes sense
Yeah.
from gravity and it may not, you may have to pump it, so, I get that, I'm just asking.
I mean, I think so too, but I think because all the houses are downhill from the cul-de-sac, everything would require a force main to get it to that point in the cul-de-sac at least.
The one thing that happens when you do it this way is that all that sanitary sewer easement, it does become lawn area, but you really have to be so careful clearing, doing anything as a future homeowner. They'll have to show where it is so that they're not digging it up. But,
That can be lawn, though.
yeah, no,
Yeah.
it can be lawn.
Yep.
Then again, I think we have to look at total limits of disturbance and, because we're gonna, still require that you meet whatever standards there are for tree removal, et cetera.
Yeah, we're
And
going.
so there'll be a whole bunch of tree removal just to get,
That's another good comment to make. We're dropping down from 4.22 acres of total site disturbance in the previous Phase 2 down to 1.44 acres for this development. So that's substantial.
That is another comment, that the tree plan will have to be submitted showing all trees being removed, over 6 dBH currently under the code, so I know you're familiar with that section of the code.
I mean, we're in the early beginning phases of this process, so we're going to review it some more.
Yeah, I think we ought to hear back from Ben first off to see his response to Lot 2, because that'll totally modify everything.
Yeah, and I think the way this, at least this particular tax map is showing up, both the tax map and this, which is a reflection of the tax map, is suggesting that the roads are still part.
It's that they're in the process of dedicating
Yeah.
that Phase 1 road.
Right.
I don't know if that dedication includes that, what was going to be,
Right in here.
that right of way for what was going to originally be connected or not.
No, it's just what the existing road is now currently.
Up to that point. So the existing paved, all this, you're going to dedicate,
Yes,
but not this in here.
correct.
Okay. Any other comments?
I have one more question. Can you go back to the property map?
Which map?
Yeah, thank you. And scroll up. Thanks. Yeah, all the way. Yep. The area on Stevens that's hatch marked, I'm not clear with what exists there and what's being changed. Is that also, is there a cul-de-sac that like a bulb in the road there, or?
Yeah, that is the existing cul-de-sac area that is extended out. It should have been. Oh,
Mike, sorry.
sorry. It should have been straightened out when they put in the existing road. Yeah, that's the way it should look now. So the hatched area, that was taken out around the bulb previously to connect it straight to the new cul-de-sac.
Okay, there used to be a cul-de-sac there.
Correct.
And you're just calling that out. And now it's, Stevens Court extends all the way to the new, well, what they labeled the temporary. Okay.
Right.
That's already been done, that hatched area's already
Yeah,
been
that was
fixed?
part of the original improvements when the road was built.
Okay, so maybe then, update that
Resting there a
on the
couple
plan
of
if there's nothing that's going to be.
miscellaneous right-of-ways that aren't being used, it appears. Where are we with cluster? And if it's
As-
required? Okay.
I'll have to submit a cluster plan, a conservation, go through that process.
So at this point, we have to get to yield if we're going to contemplate cluster. We have to find out what the as-of-right yield
Under-
is.
mhm.
Okay.
But I think that, depends on Ben's determination for one, about the rear dwelling, and then also if there's this requirement to have the road connection and how that might impact the plan.
Can we look at this as a pre-existing non-conforming cul-de-sac? Or are you saying we have to have a connection?
So I'm saying that the phase, what the original approval required that as part of Phase 2, there be a connection to Rye Hill Road directly or through the Feeney subdivision. Part of that, that was a condition of the Phase 1 approval. It was part of the seeker findings. So if you're seeking, to eliminate that, I think,
Okay, understood.
I imagine there'd have to.
Was
As
it
far as
in-
the cul-de-sac, I don't know that the length would be pre-existing non-conforming if you're adding additional lots off of it.
Subregs where the cul-de-sacs are addressed?
A65, 21. E1 is the maximum length for blocks, and then F is cul-de-sac.
Yeah, and I know these regulations have. probably existed at the time that project was approved, because zoning, we didn't,
I think it probably, too, goes to why that was considered a temporary cul-de-sac. That wouldn't be temporary, or that would be changed as part of Phase 2.
all right. Any other questions, comments, anything? No? So I'm going to recognize you. Thank you for, thank you for showing up. Again, this isn't a public hearing, so we don't have to, but we appreciate you're here, and you may add insights, and I suspect you're an interested owner. No, you have to come up here, we'll get yelled at by our tech person.
Mike, if you're going to speak,
You need
Can you hold
grab
the,
this
you can
mic
pick
out.
the microphone up.
and turn that on. Pull that towards you. Yep, pull it towards you. And then on the top, there's a slide switch. Slide it towards the top of the microphone. Let me have. Thanks, brother.
Technology.
But this wasn't one of them, right?
All right, so I'm here,
Okay,
and I was part of Phase 2, and I was fighting Lever since 2000, 2001. We even closed a couple of meetings down, and ultimately, we came to an agreement. That was for Phase 2. And the best we could, okay, he's entitled to build. But my questions were Belmont Drive. He's kind of, no disrespect, I'm just mentioning Belmont Drive. If you move up I'm sorry, I apologize,
Go down?
Apologize.
okay. This way?
So this is Belmont Drive, and this goes up to Lever. Lever's over here. My house, if you go back down, just drop, is right here. I have an easement, and I'm still fighting my neighbor, including court and paying legal fees, and he tried to get me to sign an agreement that I'd be responsible. This was never supposed to be here. Now you're including a house, and we're going back to a shared driveway. So my question is, what's happening to Belmont Drive? Is there going to be a detention pond? When you looked at the Phase 1, Phase 2, there was a detention pond over here. What happened to that? This house here was supposed to come off of the development. It was not supposed to come off of Belmont. So that's my other question. Then I spoke to Frank Lever at length numerous times. I've been trying to be able to do my driveway. I damaged several cars, tires, damaged my ATV plow, damaged my snow blowers. My wife twisted her ankle. The driveway's in really bad shape. I've spoke to Cardone numerous times about this, Mike McGinn. This has been through a whole process. There's supposed to be, or Frank recommended, a driveway maintenance agreement, but he wanted to see what the board was going to recommend. So why would I pay for a driveway that's in desperate need if you're going to build a lot here, you know? And so this, in other words, you're kind of hiding this. We share this, and then it branches off to me and to him. So this is technically Mr. Lever's. Sorry.
I'm going to go to Google. So what road was that again?
Belmont.
Belmont? Oh, but I don't know if it's going to come up on Google, but let's see. If it's private, Belmont Drive.
It's considered private.
New York.
And then the lawyer that I hired said that it's taken over by the town, which, as far as I know, it's
That's
not.
Belmont.
So I'm
That
paying
Belmont
an
Road
attorney.
was?
What was that?
That Belmont Road was taken over?
That's what he said. He goes, according to the records, that's a town road. I go, that's not true. I believe I did extensive research. But an attorney's charging me, telling me it's a public road, which is not the case. And then
Oh, I had over here.
Mr. Lever's trying to get me to sign a maintenance agreement and put me fully responsible, in doing all the repairs, paying for the whole driveway. He refused to pay for any of it. And now you're showing me a plan that he's going to make that part of his development. And the original agreement in Phase 2 was it wasn't. And this began in 2000. The project was approved. The way it was explained to me, Phase 2 was approved. A year ago, he ran into money problems, And he agreed, they were very adamant, if you would give you your bond back, you give up all your rights to phase 2, and you have to start from scratch.
So,
And now this is like fast-tracked. Oh, we're just going to accept phase 1. And the cul-de-sac was not approved. That was only temporary to get the school bus to be able to make a U-turn. So that cul-de-sac was never finished and was not approved.
can I ask you a quick question? So,
Yep.
right here by Belmont Drive, it looks like there are three
This is common. So
Those
this
are
is-
three mailboxes?
For me, yes, starts with the mailboxes, very limited site.
But
So now you're going to allow,
who's accessing it? There are three houses accessing it?
there's no more 3 houses. He gave up one of the houses, so it's only me and Mr. Lever.
Okay.
There was 3 at one time. He was renting. Whatever deal was made, they knocked that building down.
Oh, so it's.
It was like a
right off-
summer bungalow, if that's what you want to call it.
Okay.
And he was renting it out. So if he gave up all his rights in phase 2, this seems to be fast-tracked. And when I looked at the records, fast-track is for 4 homes or less, yet you're doing 5 homes. So again, his thing was to get back his money, which I understand, and I'm not here to drag this out, but I need to know where I stand before I put a brand new, I've gotten prices as high as $50,000 for a driveway where he could dig it up. I gave it to Mr. Gardone, I gave it to Mike McGinn. This has been going on since last year. I'm paying a lawyer to turn around, and they're trying to get me to sign something that says that even if he damages it with his construction equipment, that he's going to build 5 homes, I got to repair it. That doesn't make any sense. If you go back to the driveway where you went to Belmont, so if you see here, that this detention pond here, this little koi pond, that's where my property starts. This is all a right-of-way. So you can see how long this is. This is Mr. Lever's, and this is technically Mr. Lever's. So if that's all Mr. Lever's, why am I paying to do the repairs? And he refuses to do it. It's so beyond, like I said, when it's damaging the car, several rims, the front end, the spoiler, my ATV plow, my snowblower 3 or 4 times, my wife twisting her ankle, and he's been notified and documented, then who should be responsible to repair that? And he said he was waiting to see what the town board said on, do you want a maintenance agreement? But a maintenance agreement means it's beneficial to me, not when you're putting a home, and this was a quick
So you-
switcheroo. That home that was going to be near Belmont was supposed to come this way,
So-
not go up Belmont.
Your property is right where it says section 31-1-23.2?
Yes.
So at least on the tax map, it's not showing any kind, usually they would show easements or show,
Well, we've gone over it. I have the easements. I could show you my deed. I
Yeah,
could show
I
you the
think-
title. I have all
I-
that.
so-
I gave it all to Mr. Lever.
so we're not going to solve all this, but I would definitely suggest you submit whatever you want as far as your property and the relationship to the Lanza-Leva property. And then if you have a set of comments that.
So you can go, not to do, from
No, I'm just
2000 to present, I have been doing that all along.
Yeah.
And there was the tree plan, there was a buffer, and my concern was you're supposed to protect the existing homeowners, not just worry about a builder. Yes, a builder should make money, and he's trying to get in and out, and I get all that. But why I got the Rye Hill Corridor originally involved, all these people, was because suddenly everybody came in, there was a boom in building, and they came in, they were just going to strip all the trees down, and quick, fast, they made 2 mistakes on the detention pond, at least one, I don't want to be misquoted, where they said, they went with like a 25-year storm instead of a 100-year storm. And that was going to be directly in front of my house and within 30 feet. And I had little kids.
Right.
So at the time, I had legitimate concerns about my kids drowning in it, the West Nile's virus and all that. So again, the other thing is if he adds 5 homes, that is supposed to include all these studies, where if it's 4 homes, it doesn't, the way I read it. And it only looks like there's one way in or out. He said he was going to avoid the thing on Stevens Court. And the agreement for phase 2, and it was, the exact wording was, in order to build any more, that means even if you build one more, he had to have
Another access
another
point.
access.
Right.
So where is that access?
Right.
You
Understood.
know, so she's very good. I don't know, never met you before, hi. And she seems to be on top of it, thank God. Sometimes people aren't, didn't read it or whatnot. Seems like she is. But it's not, he keeps saying phase one. Most of the stuff is phase two, if not everything. From the cul-de-sac on is phase two. And the only reason why they put that cul-de-sac in was so that the bus can make a U-turn. And you could see it's breaking apart, it's temporary, and so there's no curbs
No
there.
one's maintaining it, or?
Nobody's maintaining it.
Okay.
So, and he was pushing to do to try to get the town to dedicate it, obviously, so he doesn't have to pay to keep blacktopping it or plowing it or whatever.
Right.
So, again, you can understand my point. You're building a whole development around me, and I should just be quiet and sit there? And I'm not trying to disrupt the meeting.
Yeah, no, we
I'm following the
appreciate it.
rules since 2000.
Yeah, our rules are just,
But-
again, you know, public
No, I get
hearings,
that.
so.
But there was handshakes and agreements. Originally, he agreed to pay $5,000 towards the driveway. That was a handshake with whatever that person was on the engineer. He's the one who came knocking on the door and said, if you just let him approve this, then we'll do that. They literally stopped the meeting and said, where do you want the detention pond? That's how specific it got between me and Mr. Lever. If Mr. Lever was a good neighbor, he would have told me about this planning board meeting, and he would have had me come. And he should have been here as well. And that's, Mr. Lever's 85 years old, and now it's in a trust.
I think it's in this
And it's
trust.
Frank Lever, I guess, who's in charge of the trust. So, are you a Feeney by chance? I heard Vinny.
No, the engineer.
Engineer, okay. So I'm trying to be,
No,
to help
we
you. It's not,
appreciate
I could
that-
wait to the planning board meeting, I could stall
Yeah.
as long as I can and
We-
then bring up 100 questions then.
We appreciate the input. Our attorney has a lot of the documents, most of the
But
documents,
he
so.
kept phase one, everything he said, for the most part, it's all phase two.
Okay.
So, and the agreement was that they had to have the second access. The agreement for phase two was that they weren't going to use Belmont Drive at all, and now they are. The cul-de-sac was an issue because Mr. Lever's right off of that. He was
So-
supposed to come off of that.
I would say that you should obviously keep abreast of what's happening.
yeah.
So, under the new regulations and the different lot size requirement, there were a couple lots that were lost. There's a question about a third that might not be designed to meet our code. And we have a provision in our law that talks about cluster development, where you take whatever the yield is, whatever that's determined to be, whether it's 5 or 4 or 6, and you put them on smaller lots to create more open space area. And so that's going to be one of the board's considerations, because if something like that were pursued, it may be good, it may be bad, it may buffer from other people, but other people may not be unhappy. We don't know. But so we have to go through a process still
Yeah.
under the new
This
regulations.
goes all the way back to Harley Doles, Sandra Leonard,
Yeah, sure.
Charlie Finity. That's how
Yeah.
far back this
Yeah.
goes.
And
I used to-
so we can only work with the new regulations at this point. So
Which is good because it's
Yeah.
supposed to be stricter, right? In fact, what they told me was phase two, don't worry, whatever mistakes they make in phase one, we'll correct it for phase two. That's actually what was discussed with the engineer and the lawyers, and everybody on the board assured me. And they're like, well, in theory, there shouldn't be any mistakes. If everything's to code, then there shouldn't be any mistakes. But don't worry, we'll correct it in phase two. And now phase two's gone, but then it almost seems like what benefits this gentleman, right or wrong, we'll get away, we make that part of phase one, we'll turn around and we'll allow this study. I was assured by Mr. Cardone and Mike McGinn that he gave up all rights and he has to start from scratch. And now I
Where
keep
we are.
hearing, and that was a year ago, and I've gotten the records, I paid for
Yeah.
Freedom of Information Act, FOIA, whatever, and I was assured it's back to square one.
And
So
that's
this
where we
seems like
are.
it's fast-tracked all of a sudden. I know,
No,
I'm just,
This
This
is
is
the,
the
yeah, this is the
first-
first appearance.
This is the first appearance, the first
I'm only
application.
mentioning,
Yeah.
so, because as I keep
So,
hearing phase
Jeff-
one, and we'll use the,
Jeff seems to have a question, if you would
Yes.
allow.
but I just keep hearing that we're going to turn around and we'll accept the old study, we'll accept this, we'll accept that.
Well, no, we haven't
So
said
from-
anything of that
Yeah, I
nature.
heard it tonight. I heard it a couple times.
No.
We'll look
Well,
at,
certain things maybe, other things may not.
okay.
You know, because we have to make sure that there was an interrelationship between phase one and phase two. So, for instance, if that cul-de-sac has to become permanent because it is a turnaround area and it's serving phase one, that's how there's an interaction. So there's a relationship. But that doesn't mean that the stormwater and the traffic and the design, et cetera, that's all based on whatever the new zoning is.
So Jeff brought this up. He said, Mr. Manson, he said that everything should be gravity fed. Everything's going downhill. That's what I got to worry about. You know, it's 20 acres, so if we just do the math, he could sit there and get technical. If we just say 10 acres and 10 acres, I don't know the exact math, but just we get the picture. 10 acres, once you start cutting all those trees down, all that water's coming right to me. And I don't want to be like Florida. I don't have to worry about flood insurance. And that was the big concern. So you had a detention pond. I don't see in this, his new thing, there's no detention pond. Maybe that's good for me, maybe it's not good for me. But if there was a detention pond required, now there's no detention pond. When I spoke to Frank Lever, he's like, oh, don't worry, we're not going to dig up your driveway. There's no reason why we should put any drainage down to you. Again, is this the quick fix and get the hell out and retire in Florida? And I'm stuck with all the water problems?
So we appreciate your comments. We'll definitely, obviously, you've put them in the record, so we're going to ask our engineers to look at all that. We're going to study the stormwater anew. We do need to move on with our
fine.
agenda item.
And I appreciate the time, and I
Yeah.
appreciate no egg beater, the old days of trying to shut you up 3 minutes, and then you're asking me 3 minutes worth of questions and never let me speak. Thank you.
So, but again, keep informed, and if you have comments or documents, et cetera, if you could get them in to our planning board secretary, then she can get them to our attorney and to the engineer.
Thank you.
I appreciate it, thank you.
I think we covered really what I was going to say in that.
I think you did, because you had mentioned that was your property, so thank you. Noted, I appreciate it.
But essentially, this isn't really phase two anymore. Anything that was relating to phase two, because it wasn't filed within 3 years. Do I understand correctly, Ashley? We're essentially looking at a
So it's-
new and separate subdivision, and we're starting from the beginning of the process. It's like any other subdivision that would come before us and say, I've got one piece of land, I'm planning on dividing it up into 5, and we're starting really from scratch.
To an extent where it is definitely being treated like a new subdivision, but there are things that were, if there are things that were required as part of phase one to happen in phase two, that's still certainly relevant to this new subdivision.
As far as stormwater design, the site layout has changed, like the applicant was saying, the tree clearing limits are different, they're going to have to provide a whole new stormwater design, whether it's amending the previous SWIP or submitting a whole new one, but it will look at it as if we're looking at it for the first time.
Sorry, I'm just going to ask a quick question. Do we have an as-of-right survey of the property? What's on the property now?
Yes, yes. In
Submitted,
existing
or
conditions?
can you submit it, or was it
Sure.
submitted?
No,
Okay.
it was not.
Just so for instance, we're seeing kind of sanitary lines. I think we know where they end and what's proposed, but it might be useful to actually see a survey which might show that information a little
Sure.
more
You
clearly.
can get that in the next submission.
Great, thank you. To get an existing survey map of the property.
Called something.
Conditions,
An as-of-right.
Existing
that shows
conditions.
what's existing I guess as-of-right isn't quite right. It's like an as-built, yeah.
In the seeker consistency analysis,
It's more a comparison and
right, but the one thing that it does call out is stormwater facilities, at least town stormwater facilities, and in the original approval, there was a stormwater retention pond, and now, at least the way it's laid out now, you don't expect that to be. What's changed from the original design of Phase 2 to this new proposal where stormwater retention might not be necessary?
We're decreasing or not improving over 500 foot of road that was proposed, and we're decreasing the amount of disturbance by almost 3 acres by removing those additional 2 lots.
Yeah, I see. So there's a lot less, more
Correct.
trees are.
Yep.
Property.
Exactly.
Okay.
So there is some information in here in the packets, just so you're aware. Deeds. So if anyone's interested in taking them.
74?
Yeah, because I noted that your name's on one of them, Mr. Andrizzi. Okay, thanks. I have to stop asking you because we're not on the mic. Sorry. Anything else we want to cover tonight? Again, I think this is a work in progress. It's just the start. Procedurally, we're at the start, and we have to determine an as of right. We have to get input from Ben, and so I don't think we're ready to even contemplate seeker at this point.
Yeah, prior to us making a new submission, we're going to wait till we hear back from Ben.
Yeah, I would.
Great. Thank
Great.
you.
Thank you. Appreciate
Have a nice
it.
evening.
Have a good night. All right. So the tree preservation code, that's something that we are going to
The
address.
board already authorized you and I to work together to finalize that, so we could do that. All that, Jeff?
I'm sorry, I was updating
I
my notes.
believe at the
on
last
Leva.
meeting, the board had authorized Bonnie and I to work together to finalize those revisions.
Correct. Basically, what the discussion was that everyone who was here from the board felt that they had no further input. There were some things that Ashley wanted to clarify with you to make sure that the things that you wanted to communicate to the town board were communicated correctly. I essentially had one comment towards the thing, and Ashley included that in her draft. So we did do a quick, we did a motion that Ashley could work with you directly, and and the final version that you came up with Ashley is acceptable to us.
Okay.
So,
Thank you.
yeah.
All right, so the agenda, okay, so that's, Ashley and I will work together.
Whenever,
So that, because I know the
get on a quick call, and that'll
board
probably
wants
be easier
to, yeah,
to,
and the board wants to get it.
yeah,
out
I'm
of
sure.
Get it adopted, so. I don't believe I received June 13th minutes. The June minute? Oh, you got May minute.
Take a look. Right, that's what I thought.
That was May, I believe, or April, one.
No, at the last meeting, we looked at, did we have a quorum for that?
I was looking at my minutes table, and the last thing that I had that you had sent to Jeff was in May. So not June. And in fact, there are minutes that are showing up on board docs that, for instance, I think there's another meeting in June that we don't have, even though it's in board docs. So they're not being sent to us. I don't think we have any other business we have to go over. If you want to head out, I don't want to keep you. Normally, you guys head out around minutes time. Not that you have to, but. Thank you for being here.
I'm away Tuesday to Thursday next week, but around tomorrow.
Okay. So, but it's June, July, August, September, and that's 4 months, and well, Noreen, I feel that I need to say it in front of the planning board.
Fine, but we don't need
I know that we're asking you,
minutes that,
and why do we not have them?
I thought they were all forwarded to you that are done. I didn't realize that they were not.
So what I see in
When I
board docs, what I saw in board docs are June.
Again, I don't feel this needs to be done on TV.
Well, I feel that it does.
Well, then I'd like to discuss.
You can. But
gonna see
I'm very tired after this number of years having to ask for minutes when it's just it's one of your functions.
It's one of my functions.
And it's not getting done. It's just not getting done. And that's where I will leave it, because I know you're not feeling well. But I think publicly, I'm tired of it. So with that, unless anybody has anything else to say,
I do.
okay?
Orange County Municipal Planning Federation, which Town of Monroe is part of, is having their annual dinner on Tuesday evening, October 29th. That starts at 5:30 at Palacio in Goshen. And there's going to be a keynote speaker there, which would involve covering training time as well. So
What day is it?
it is October 29th. It's a Tuesday evening.
That's the 5th, so that, okay. I'm just looking at, it's the 5th Tuesday of the month. You said
Fifth,
October 29th?
right, so we don't-
So
yes,
there
it's-
usually aren't meetings that,
Right, we have our meetings the 10th and the 15th. And Tony Cardone did look into it, and we seem to still have money available to us for training credits, so this could be covered as part of that. And so I want to make everyone aware of that. I guess I'll forward this out to
Yeah.
the board and
see who's
maybe see who's
interested in going.
and
Sure.
work on coordinating that, if that's okay with you?
Yes.
Okay. It is my intention to go, just double checking my calendar, but I just wanted to let everyone know about that tonight, and we'll cover it quickly next Tuesday with the members who aren't here tonight.
Okay,
All right?
sounds good, thank you.
Yes.
Having knee surgery that day, so I won't be attending.
Okay. That's a pretty good excuse.
Alcohol will take care of it. We could wheel you there. All right, so, yeah, we'll take it up at the next meeting then.
Okay, yeah, and I'll get this out to the board in the meantime.
So if there's nothing else, I will make a motion to adjourn. May I have a second?
Second.
All in favor say aye.
Aye.
Any abstentions, any nays? Motion carries. Meeting is adjourned. Thank you, George.